Good morning. My name is Jeff Ketchum. I am a staff attorney at Northeast Legal Aid, here to talk with you about some issues that we see that parents, relatives, and guardians may have around the opioid crisis. Our office has a project called the Caretakers of Children at Risk project that provides assistance to caretakers of children in families that are affected by substance use disorders. You may see on our slide, I've got the term SUD. That's the shorthand for substance use disorders right now. In Massachusetts, there are estimates that there are about 90,000 children in Massachusetts being taken care of by people who are other than their parents. And these are the children, and these are the families that we're looking to help with. There's my contact information up there in the slide. We're going to talk today about options that caregivers may have when they may suddenly find themselves in a position where they're needing to take care of some children that might be related to them. And here's a list of the short options. I'll go through them individually, but this is just a summary. Top two are a little bit less permanent, less formal than the rest of them. But they're the caregiver authorization, temporary agent, and then there's the guardianship class also. Here's also some terms we may use. Guardianship refers to guardianship of a person. You may have heard of the term conservatorship. That has to do with actually property. So guardianship refers to the person. Conservatorship may deal with property of a person. There may be crossover. There may be a person may be a person's guardian as well as their conservator. Ward or minor refers to a minor child of the guardianship, which is what I will usually be talking about here. Commonly, the guardianship was thought of as a guardianship decree. There were some changes in the law. It's now called a letter of appointment of guardian. And that change was several years ago. Some newer concepts are the Caregiver Affidavit and the temporary agent. Those are both parts of the Massachusetts Uniform Probate Code. So moving first to the caregiver authorization, there's the site of the statute. Not as important to people, but that's where the site is. And in summary, this is a caregiver affidavit is executed by a parent to appoint, in a way, another caregiver for the child. So, as we says, a parent doesn't give up any rights. It just gives somebody else some authority to make important decisions. In this situation, a caregiver authorization, when it's executed, one parent can do it. They don't have to give notice to the other parent if they wanted to do this. And there's also no court involvement with a caregiver affidavit. Couple of things. Importantly, a parent can only execute a caregiver authorization to somebody who the child lives with. So you can't, the child must be living with the caregiver. And again, the parent keeps all of their parental rights. They can basically, in writing, revoke it at any time. Here's what a caregiver can make decisions about. Health and education only. Healthcare decisions and education decisions only. As far as the nuts and bolts of it go, it's signed by the parent. There has to be a couple of witnesses, and it has to be notarized. The caregiver also has to, in writing, accept the authority granted to them. So healthcare and education, that means access to pediatricians, medical records, access to the school special education file, things like that. Valid for 2 years. Like I said, it can be reauthorized, but it can also be revoked at any time. So what are the possible uses? One, perhaps obvious, one is a step-parent situation. A step-parent doesn't have any legal rights or legal authority to make decisions for a child. So that's one. Informal kinship. We just have generations of families have generations all living under the same roof, and it might be that grandfather, grandmother is the one at home most of the time, and the school would call the grandparent, and they would need some sort of authority. I also put unaccompanied youth. I think we're hearing a lot of that in the news about children who are coming across the border with their parents. It's also a situation where these may be citizen children of non-citizen parents. But the non-citizen parent can give somebody, say, a citizen or a documented relative in the household the caregiver authorization. Kind of important because sometimes these people are facing deportation, and they can be whisked out of a child's life pretty quickly. Another one might be a live-in nanny. Does anybody have any questions about the caregiver authorization? No? Okay, yeah. Here's a limitation on it. Sometimes a parent might want a child to go to a certain school or in the school system. You can't execute the authorization to do that, not for the purpose of it. It has to be, it can't be used to do that. It also can't be used to overcome or bypass a court order about a child. Say a parent does not actually have custody, legally speaking, of their child. They cannot execute a caregiver authorization to another caregiver if they do not have the legal authority to do it. So that might be a limitation on there. That, again, parental authority continues. In the caregiver authorization idea, parent can set sort of specific limits on the decision-making of the caregiver as well. Say, yes, I want you to be able to speak with the pediatrician, but you cannot speak with my child's therapist. Or, yes, you're authorized to pick them up at school and sign them out sick, but you're not authorized to look at the IEP or something like that. Those limitations can be set in the caregiver authorization. I think this might be a little hard to see. Yes, I have an example of it. It's also available online if you were to just get on the internet and look up caregiver or authorization affidavit. You could find it. Maybe even on the court website, the probate and family court website. A lot of these things we're talking about are available on the probate and family court website. Another more temporary, less formal situation that you can set up is a temporary agent affidavit. There's also a form available for that. This is a little bit of a weird, and I wouldn't say weird, it's a little bit of a different situation. It's very short term, valid up to 60 days, but it can be renewed. Signed by a parent appointing somebody to be the child's temporary agent. 2 witnesses, has to be accepted by the agent. However, the other parent is entitled to notice about this if you know where they are. Even if there is I think arguably people would say even if there was like a restraining order between the parents, the other parent might, this is a legal process that the other parent might be entitled to know about. That's a little bit up in the air. If there's no contact between the parents and there shouldn't be, then you're probably okay not giving notice, but that's what you have to be aware of. This is also something where there's no court involvement. And there's no notary required, as I said there. So again, it can delegate some power. Actually, the temporary agent affidavit grants broader power than the caregiver authorization. If you recall, the caregiver authorization was limited to healthcare and education decisions. This can be broader. And there's some examples of when you might use it. A parent is traveling out of the country, a parent is going out of state for work or something like that. Maybe for a shorter time period, they might want to execute that. This, I think, this comes up less often in the area of work that I'm doing with caregivers. of people who aren't, of minor children. But this might be something that could be considered in some situations. I think I brought, yep, there's another example of it. It's kind of small in the slide, but that's what it looks like. It actually looks very much like the Caregiver Authorization Affidavit. There's some differences. So kind of the big one people are talking about is the guardianship, and guardianship of minor issue. That's where we're going to spend the most of our time today. And just some general things about guardianships. It's basically a guardian who's appointed or goes through the court process. It acts as a parent. They have the same and similar authority on making decisions. These are the standards they must, that a guardian must exercise: reasonable care, diligence, and prudence. And we always talk about the best interests of the child in a lot of these considerations. Okay, so what types of guardianships are there? There's parental, or I should also say parental or guardian appointment. So a guardian can appoint another guardian, I guess is what I'm saying there. So, but we'll be talking about usually parental appointment. There's the temporary guardianship, which is what a lot of people are encountering. They're having to go back to court every 90 days for a temporary guardianship. Permanent guardianship, I put that in quotes because there's really not such a thing in the law other than what it means is the guardianship is not temporary anymore. So it's not, it doesn't say, the law doesn't say it's permanent, it's just not temporary. Yeah, go ahead.
Is for guardianship and custody, having custody of the children, the same word?
So a guardian has custody.
So when you say
yes,
my children are in my custody, they have guardianship?
If you're a parent, it's not called a guardianship. Yes, somebody else. Yes.
Okay.
Yeah, well, so that's a great question. Actually, I'll back up just a little bit. The concept of custody under Massachusetts law has two ideas: physical custody and legal custody. Physical custody is where the child lives, day-to-day activities of the child, basically where, who is responsible for the day-to-day caretaking of the child. Legal custody is a parent or other person's authority, right, responsibility, obligation, I would say, to make decisions about the child, like, health care that might be needed, education decisions, other things like that. So legal custody is the decision making, physical custody is kind of the day-to-day, what you think of. So, people like to use the word custody kind of interchangeably between those, which is okay. But you just have to be aware that the concept. So a parent may have physical custody of children, but not have legal custody because the child might be in DCF legal custody or something, or somebody else's custody, something like that. Legal custody. So those are the two concepts.
Thank you.
Yeah. So let's talk first about the parental or the guardian appointment of a guardian. This is what we commonly maybe see in a will. Parents write wills and they say, I want this person to take care, become the guardian of our children after, worse, if something were to happen to us. It doesn't have to be in a will, but it could be in another kind of document, but usually it's you appoint a guardian for your kids in your will. Initially, it doesn't require court intervention, but if a person does pass away and appoints a guardianship, say in their will, the person appointed does have to go to court to get that confirmed. And they usually have to petition within, I think it is, you have to petition within 30 days.
Do they have to be informed before that happens? I mean, do I tell my brother that you're going to take care of my children when I die, or do I say, surprise?
I would suggest that you talk with them before, yes. And we can, that's another issue that I touch on when I talk to people sometimes. Just for an example, DCF comes knocking on a grandparent's door late at night and says, we've got these kids that need to be, and obviously you're the grandparent, you take them in, and you're like, what happened to their parent? And maybe their parent, they don't know where they are, or maybe they're incarcerated, or maybe they're worse. The issue then becomes a grandparent suddenly taking care of children. Okay, what happens if something happens to me? And yeah, that's the issue sometimes. With the appointment, back to that a little bit, it isn't just, say, the death of a parent. It might be incapacity of a parent. A lot of people execute a power of attorney or a healthcare proxy or something like that. You can sort of do that within the context of having somebody else to take care of the children. So it might require some medical verification, but it is essentially, that's when they become effective. Or it's kind of self-executing the guardianship, but it does have to be confirmed later by the court. So yes, like I was saying, go to court within 30 days, and again, it may become permanent, a permanent confirmation by the court, but I put permanent in quotes because it's basically not temporary. A guardianship, any person interested in the care of the ward or the minor can petition the court to terminate or remove a guardian. So that's why it's kind of not permanent. It's just at any time. It's one of those things in the law where basically the court has oversight until the child turns 18. So when you do go to court for confirmation of the guardianship, most of these are court forms that you can have. There's a petition that you can file. The guardianship would have to accept the appointment, and usually a copy of the document in which they were appointed should be filed as well. I think I sort of touched a little bit briefly on the termination or the end of the guardianship upon appointment. It's not permanent, again. It can be revoked kind of at any time. Another issue when guardianships come up is the idea of objections. Okay, so what's an objection? Basically, that is a challenge to the guardianship filed by somebody. Who can file them? Well, believe it or not, anybody. Just about anybody who's interested in the care of a child. And when we say anybody a lot of the times is the Department of Children and Families, because they are the state agency charged with the welfare and best interests of children. Or some other, could be a neighbor, another relative, and the child can file an objection. And usually the cutoff age as to when a child maybe has more say in their care and things is 14. That's when the law has decided that the courts might listen to kids a little bit more. When they're younger, it's hard to feel. But when they're 14, sometimes kids are perceptive, kids are smart, and kids can make informed decisions. So, yeah. Let's see. When a guardian is appointed, so let's just hypothetically speaking, a guardian is appointed and the parent is not. It's not because the parent died. It's not through the will. Parent still has decision-making rights. This can sometimes lead to conflict between the guardian and the parent. When push comes to shove in court, if the parent isn't making an outlandish decision that harms the child, the parent's decision would usually override. And again, like we talked about the caregiver authorization of the temporary agent, a parent in an appointment can limit the decision making of the guardian. So that was kind of a appointment by guardian or caregiver or parent in a guardianship situation. The other situation is actually what we probably see most, what I see a lot of is the court appointment. And that is when, again, DCF knocks on the door, we have kids, then somebody needs to take care of, and the grandparent is left with, well, what do I do now? It's going to court to seek guardianship, seek court-appointed guardianship of a children. So, these are the situations that it happens. Something happens to a parent. Sometimes the parents agree to guardianship. It makes it a little bit less adversarial, but it isn't always that easy. But those would be the reasons for filing of the guardianship. Sometimes, the police or the DCF or somebody tells the grandparents, you need to go do this, and they will. So we're going to try to walk through that a little bit, because it can be an overwhelming process under stressful situations, and not everybody gets legal counsel or can afford it or something like that. A couple of the questions asked: Can a case be filed in Massachusetts? We're close to New Hampshire here. We're close to Maine, so people may have relatives that are kind of across the border. Sometimes incidents occur in different states, but generally, if the child lives somewhere in Massachusetts, you file in Massachusetts. What court? That usually is dependent on where the child lives. If that court may be inaccessible to a potential caregiver, they could probably file it in the county where they live. So it's in the county where the child lives, or where the guardian would live. Sure.
So if a child is living in Maine
Mm-hmm.
and the guardian is in Massachusetts, do they have to file in Maine and Massachusetts?
You could file. If you file in one place, you shouldn't need to file in another. So the caveat I would say on that is, under guardianship rules, I think courts can say you can't move out of state with a child. That's a potential without court permission. So what we're sort of talking about with jurisdiction is, in Massachusetts, the state itself, the probate and family courts in the state, don't have jurisdiction to make a custody determination until a child has resided in the state for 6 months. Absent some emergency. Maybe there's some emergency, and maybe this guardianship or this particular situation is an emergency. But usually it's the state doesn't have jurisdiction until the child has lived here for 6 months. So it may be that because it's across the state issue that it might have to be filed in another state. I'm only licensed in Massachusetts, so I can't tell you what the rules would be for another state. I hope that kind of answers the question, yeah. It can be a tough call. Oh no. I may be frozen. So I think maybe we'll see if my computer comes back on a little bit. I'll just keep going. So there are some situations where people cannot be appointed guardians. And the two situations in the law are if a person is being investigated or has charges pending for a crime committed against the particular minor child, usually assault and battery or neglect. And the court has some discretion to limit who can be appointed the guardian. So that's just one thing I sort of wanted to mention on the outset. Another question that a lot of people have is, okay, what about attorneys and guardianships? So I have sort of bad news on that issue. A person petitioning for guardianship has no right at this time to be appointed an attorney by the court. There are some people in a guardianship case who are entitled to be appointed attorneys. The child. And parents of the children who may not be able to afford an attorney have the right to be appointed attorney. So, and the thing with this is that somebody needs to ask too. The courts aren't out there offering attorneys to people. You have to ask, especially for the child. A judge may look at a situation and go, wow, boy, this child needs an attorney, and they might do it themselves. But there isn't a right for a person petitioning for a guardianship to have an attorney. There may be a right to parents and the children. There is a proposed law in Massachusetts to say that low income, or what's called indigent petitioners for guardianship, people seeking guardianship, be extended this right of appointment of guardianship. It's going through committees in the legislature. That's about the status of it right now, and it's been being kicked around for a little while. So there isn't really resolution on that case. Another situation where there may be appointed a guardian is, or appointed an attorney, excuse me, is when somebody files a petition to remove or terminate a guardianship. The court has discretion to appoint an attorney for the guardian, as well as the person who may be seeking removal of the guardianship. So there are some situations for some of it's a little bit hard to sort out, but basically with attorneys, it's low-income parents and the child could be entitled to attorneys. Let me see. People who could potentially be appointed attorneys are entitled to notice about it, and what this usually means is probably somewhere at the courthouse there's a notice saying, if you're involved in a guardianship case and this is your situation, you might be appointed, you could be appointed attorney. You have to assert you have to ask though. So that's if you're involved and then ask, ask. It doesn't hurt to ask. The judge might just say no, but it doesn't hurt to ask. So I mentioned that parents can be appointed attorneys, and I think a lot of people ask the question, well, this parent is a really terrible, they say this parent is a really terrible person. They're out there, doing whatever, all of these, and they're getting in all of this trouble. Why would they get appointed attorneys? And the way I put it is that somebody may not win the Parent of the Year award, but they have a constitutional right to parent their children. It's just such a fundamental right that it gets protected by the law. And I don't think many people would necessarily argue with that. You might scratch your head, but it's not something to necessarily argue with. So parents are entitled to due process. This is the United States Supreme Court has said this, the state Supreme Court has said this. You're entitled to due process because your parental rights are fundamental. Maybe it's not fair, but that's in some situations, but that is the law behind that. So so now to go back a little bit to the idea of a court appointing a guardianship. A petitioner goes to court, fills out all the paperwork. There's a lot of paperwork. And even when you think you're done, you're probably not, unfortunately. If you're in a situation where you have to go to court and a parent is saying, I would agree to this guardianship, then the parent's wishes would probably be allowed by the court. A lot of times people ask the question, well, I'm the grandparent who's the most involved in their life. I should have priority. There's no priority among relatives. The priority is determined by the parent or the court or the child in some situations. The guardianship laws do not set out priorities among the relatives as to who gets the first right of guardianship. So it might be, I've seen cases where there's two sets of grandparents, both equally care about the children, both equally able to take care of the children, where they're fighting over the grandchildren. So the court has to, court has to determine what's the best interest. When goes through the court process and a guardian is appointed, guardianship continues regardless of the location of the child. So if, going back to the question before, if a guardian is appointed in Maine and the court in Maine says, great, grandmother in Massachusetts can take care of the child, they can move to Massachusetts, it's going to continue regardless of where the guardian lives. So it's going to be valid, it would be valid in that way. The court that appointed the guardian would probably retain jurisdiction unless maybe it looked like this child's going to move to Maine permanently. Let's get something in the Massachusetts court at that point. Or, sometimes the state courts can get on the phone with each other. The judges can get on the phone with each other and say, here's the situation. There's kind of one big, it's not working still. There's one big limitation on a guardian's decision-making, a guardianship petitioner's decision-making, and that's a legal concept called substituted judgment. And I think the best way I could summarize that is that a court must authorize certain psychiatric treatment, maybe medication or admission to a psychiatric facility for the minor child. So a guardian has a lot of authority to make important decisions, but when it comes to certain types of psychiatric, potential psychiatric treatment, you have to get court authority to that, for that. So, talked about it a little bit before. I'm going to come back to the idea of the permanent guardian. Again, it's not in the law, but it basically means not temporary. And when I say not temporary, that means that it's an appointment basically until the child is no longer a minor. This is kind of the biggie in guardianship. This is where there is the potential for a long, drawn-out court process, because we're talking about, again, we're going back to talking about fundamental parental rights. So a petitioner who is maybe eventually seeking guardianship has to provide notice to a whole lot of people when they file their case. If the minor is over 14, the minor is entitled to service of process. Any person who's had their care, has taken care of the child within the last 60 days is entitled to notice, except foster parents. I'm not sure why that's excluded, but it's foster parents is basically supposed to be a temporary situation, so that may be why. Any parent who's still alive is entitled to notice. If the minor, this probably happens very infrequently, but if the minor is married, the spouse of the minor is entitled to notice. There are some states, I think Massachusetts included, where you can be married before you reach majority. You have to, before you're 18, you have to get parental permission or something like that. But there are some states where it's still, where it is a thing. If the minor has an idea of somebody that they would like to have be appointed the guardian, then that person is entitled to notice of the court case. If the parent has nominated somebody, but the guardianship is not, this petitioner is not the guardian that they nominated, then they would have to give notice to the parents, who the parent would say prefer to be the guardian. If there is already a guardianship underway, you'd have to give notice to that guardian. This list is really starting to get long. I guess that the last big one that I would just notify is that if the minor is entitled to or receiving veterans benefits, then the Veterans Administration is supposed to get notice of the guardianship. Yeah, I haven't seen it yet in my experience, but those are people who get notice of this potentially long court process, which can ultimately end up in a hearing where a contested hearing where the judge has to make a decision about it.
I'm sorry, did you say that the child can pick who they might want to be or petition to?
So a child who is over 14 and over, can express a preference.
Besides being
Yes.
a conflict of interest, if it's like a social worker or a teacher they're choosing or
Yeah.
a police officer, could that potentially happen?
That's a great question. I guess the courts are usually dealing with maybe a child saying, I want my older sibling to take care of me, or something like that. A non-related person, I mean, I suppose that a child could at least express that preference, but if it's a social worker or a police officer, I think in their professional discretion, they could, they would understand that they need to decline that kind of thing. But I don't know that there's any legal impediment necessarily to that.
So it's something that happens in movies and TV, but not usually
Yeah,
real life.
yeah, yeah, yeah.
Okay.
Now,
Yes.
If the minor has emotional problems or psych issues, etc., do they take that into consideration because they want to go and live with their brother, let's say, that
Mhm.
is a drug addict?
Mm-hmm.
Do they have the right to make that petition?
I guess what I'm going to say is that in this area, the minor has a right to express a preference,
Okay.
and the court has a right to listen to that. The court has a right to listen, to hear it, but the court has to make the determination as to what is in the best interest of the child as well. The court may, if it's brought to the court's attention that this older sibling is not appropriate, then the court is going to has the discretion to say, well, we can't appoint that person, even though the minor expresses that preference.
Now, anyone that is a potential guardian,
Mm-hmm.
do they get investigated to make sure that there's nothing in the back? Like a quarry or anything of that sort, to say, this guy's laundering money. Yeah, he may be fine, but he's laundering money. What are we doing with that? Is that bringing him, the child, or her, the child, into a bad situation?
That's a great question. That is, as part of the process, the court will most likely do a Corey check. Not a Corey check. The court isn't going to do an investigation unless somebody requests it, most likely. But if things are flagged on a Corey, then the court will definitely know about it. And it also might depend upon whether or not the Department of Children and Families is involved. They have a vetting process. That agency has a vetting process for and investigation capabilities. Not every guardianship or petition for guardianship involves the Department of Children and Families. It doesn't. If DCF is doing the petition itself, they're usually in juvenile court, but guardianships are also available in probate and family court, which is where where I would probably recommend that most guardianships get filed. The probate and family courts have a probation department, and it's not like a probation officer at a police, for crimes or things like that, but they have probation officers who can do limited investigations, background investigations on people. There's another process called the guardian ad litem in court, which is, in short, ad litem is, I believe, a Latin term for guardian for the case, for the suit. And usually what their role would be is to do that investigation, to say, and maybe lay out the facts for the judge, and if requested, the guardian ad litem can make a recommendation, but that isn't always their role. It's really fact gathering for the judge. Yeah. Mm-hmm. So let's jump ahead just a little bit. all right, we've got this guardianship appointed. So you've gone through the process and it's all been appointed. You have the guardian's supposed to do a couple of things during the period of the guardianship. First of all, take care of the child in their best, make all the important decisions in their best interests, and file an annual report with the court. You have to do this every year. A lot of people don't realize they're supposed to. And I don't think there's necessarily any penalties from the court, but this is something that has to be done. Things that are in the report there's a form available on the Probate and Family Court website, so you could look at it more specifically. But it's, a list of who's living in the household, what grade the child's in, how they're doing in school, any outstanding medical issues, things like that. It's not heavy lifting, it just needs to be done on an annual basis. So, guardian has been appointed. What if something comes up during the guardianship? The guardian becomes incapacitated, something like that. Or can't continue to make the decisions. There is a legal process called a special guardianship where the court can appoint a limited short-term guardian if something happens to the guardian. The issues with that are who's going to do it sometimes. And sometimes that might be a place where the Department of Children and Families comes in. I've never really seen it. Once the guardian is in place, I haven't seen it yet. So once the guardian is in place, again, I'm going back to my putting permanent in quotation marks. There are situations where the guardianship can end. Maybe some of the obvious ones are if the guardian were to pass away, or if the guardian, or if the ward, the child that's the guardian that's being taken care of, passes away, or maybe is adopted, or gets married, or reaches the age of majority. These are some sort of just like events that trigger the end of the guardianship. But also, during the guardianship, things can happen. The guardian could resign if they wanted to, and the court would be in the place of having to figure out who might be next. Or interested parties, as we were kind of talking about before, can file a petition to remove the guardian. That would trigger a court, eventually a trial, most likely, if depending upon the circumstances there. So that would be kind of the events that can make the guardianship no longer permanent. Yeah.
Okay, what if you have a child that is mentally or physically affected? Does the guardianship continue? I mean, do they get it till they're 23? Let's say if you have psychomotions or you have physical things, and they say, well, I'm 18, I can leave, but can they?
So I would say the short answer to that is once they turn 18, yes, they can start making their own decisions. That's what our law has said. There is a process for what we have been talking about is guardianship of minors. There is a guardianship of, I'm trying to remember what the term is. There is a guardianship process for people who have reached the age of majority. I don't talk about it because I don't deal with that as much, so I don't know as much. And there's times when there needs to be a guardian really late in a person's life as well, when they become incapacitated. So yes, there are some provisions where it might end on the 18th birthday. At that point, if it needs to continue, you'd have to, a whole new case would have to probably be started. Yeah. Under some circumstances, the DCF can keep cases going. Juvenile cases might extend past 18. Yeah. What we see when there's a say, a traumatic event that leads to a need for somebody else to take care of a child, what we see a lot of are the temporary guardianship idea. This is, emergency situation. You get to court, you file for a temporary guardianship. That's the 90 days idea that a lot of people may hear of. That is in the law. It's the temporary guardianship, and that has to be. That is, if there's a showing, if you show the court, somebody comes in with, and petitions the court, it makes a showing that this child is in substantial, could be substantially harmed. Their welfare could be substantially harmed. Usually set for 90 days, and the court will review it after 90 days. So the temporary guardian idea is in the law. It's the permanent that's a little bit less. It's like filing, you've heard the term like filing for a temporary restraining order or for a preliminary injunction in a case. It's saying, Judge, here's an emergency situation. These are the circumstances. I need this now. And, the court determines whether to do that. It's the procedure itself is very similar as to filing for a permanent guardianship. You file a petition, you file a motion, things like that.
If a child, let's say they've reached maturity,
Okay?
and they're in a terrible car accident, they've already come out of their guardian's thing, and they're in a terrible car accident at 20, can they have, if they have no other relatives, can they have a guardian appointed? I mean, like if they're in a coma or in a hospital, someone has to make decisions, or is it just going to be the court?
Yeah, so you've asked a great question that I think the way I'm going to go about answering this is that in Massachusetts there is not yet, put it this way, there's work behind it, there is not yet a public guardianship option where in a situation like that, maybe a person doesn't have anybody else to make any decisions or anything like that. Maybe there is nobody out there. There isn't a public, so the idea of a public guardianship option is that there is an agency or there is a court
Order or something.
Order something that somebody would be able to make these decisions for that person. It's in the works. I will tell you that. I know I have a colleague who works in my agency. This is like his thing. This is his thing. He's been fighting for it for a long time, and he's on every commission or whatever to try to get this going, because you nailed it. There are people who either maybe younger like that, they just don't have anybody. Maybe farther, later on in their life, there's a need for a guardian, and they don't have somebody to do that yet. So it takes money. And then, we all know some of the limitations on that. I'm talking about situations where we know where there's an identifiable person. Yeah. Let's see. Very sorry about the presentation. I feel a little bit constrained or handcuffed here, but I will carry on a little bit. And maybe just kind of summarize some of the ideas behind guardianships. There's temporary, there's permanent. A lot of people ask the question about who gets attorneys. Basically, the two people who could get attorneys are the child and low-income or indigent parents. When is the court going to appoint a guardian? That's when parents are deceased or incapacitated, parents consent, parents have their rights terminated. That's a whole nother thing. That's usually by the state. Maybe the parents voluntarily surrender the child for guardianship, or parents are found to be unavailable or unfit.
What if they're incarcerated forever? If the parent is incarcerated?
I would-
Does he give up his rights or her rights?
They do not. They don't give up their rights, but I would submit that that parent is unavailable, because that's the legal concept.
So they
Unavailable.
would get a guardian,
Um,
child would get a guardian if that's the only parent?
If there's somebody who could, yeah, yeah, yep.
Okay.
Mhm.
What's the difference between being a permanent guardian and adopting, legally adopting? Are the rights different?
Yeah, so the rights are different. And it can go to some stuff later on down the road, but the big difference is, so a guardian appointed acts as a parent, an adoptive person becomes a parent, legally becomes the parent of the child. And there are some different sort of legal rights, obligations, and responsibilities that arise from the adoption situation. This person becomes legally your child. It could have been your grandchild. Grandparents have adopted grandkids. So legally, they become their parent. There may be reasons to do that for a grandparent to adopt a child. But the guardian is like, it's less permanent in a way. Adoption is permanent. Yeah. Yeah. That's from a legal standpoint.
Yeah. Is there any financial assistance to someone who becomes a guardian?
So that's a good question. Yes, there is some. And that's kind of a bit of another presentation that I could go into that am actually glad to jump into a little bit right now. When you become the guardian, if you are, so you may be entitled to, you may be eligible for some benefits from DCF. If you're maybe going through like a foster or adoption or kinship care program with them, there may be some stipends, some certain benefits that are available from DCF. One of the big ones is, and depending upon your outlook on this one, is support from DCF. A lot of them are social workers, and they can provide referrals and help with care and connect you with programs and things like that. DCF has different levels of involvement in people's lives, so there's support. There are, if you were looking to adopt, there are DCF adoption stipends that are available. Another benefit of working with DCF is if you become a licensed foster care caregiver, then you can, you can get foster care stipends as well. It's not, people who are doing foster care aren't out there to make money, but there are some benefits that are available.
I'm just thinking of grandparents who are retired and living
Yep.
on limited income.
Yeah. So if you're just going to, I say just, but if you're going to just become the guardian of a minor child, you may be eligible for some benefits for the child, such as SNAP food stamp benefits. If say the child is disabled or the child's parents were disabled, there may be Social Security benefits that are available to you. And the Department of Transitional Assistance has, it's called Temporary Assistance to Families with Dependent Children, TAFDC, based, kind of more commonly known as welfare, could be available to a guardian. So there's sort of two ways of looking at the TAFDC idea. If you're very low income, it can be a huge help. But you can also get a guardian, a caregiver. We did that caregiver authorization. We talked about that earlier. Caregiver and a guardian can apply for TAFDC for the child only, which means that the Department of Transitional Assistance can give a grant just to the child without considering the income, assets, resources of the rest of the household. It's not a lot of money. I want to say it's about $300 a month, but a lot of times that's a great help. It can lead to, that can be a lifeline. Absolutely, and a lot of people just don't realize that that's available. Normally, when the situation applying for welfare or TAFDC benefits has to look at the income of the rest of the house, and it's a parent applying with a number of children or something like that, and they may be capped. Heard of the TAFDC cap on number of kids and kids born after a certain time. Some of those rules don't apply. So that can be a benefit. The child may also be eligible for mass health. Maybe just for the child, if you can't. I mean, if maybe a younger grandparent is working and has family health insurance, but can't get a grandchild on their plan for some reason. That's just somehow insurance might be written. You probably get mass health benefits. Yeah. Definitely would get mass health benefits if the Department of Children and Families was involved. This is another place where I kind of wish I had my slides, but I don't. But this is just a little bit of the nuts and bolts of filing a court petition for a guardian. I think I mentioned before, there's a lot of people who get notice. So usually the court will at least give you, when you go, if a person were to go to court and ask for all the forms, the court would give an indication. All right, they might even just hand you a list of, okay, check off this list. These are the people that you need to file with. But there's also a lot of paperwork. There's the petition itself, which is like a court complaint, basically, but they call it a petition because it's a petition for guardianship. There is a document called an affidavit disclosing care and custody, which is a statement by the person filing the petition about any other court cases that might involve the custody of this child. So if they know about them, maybe they don't know about them, but maybe the parents are divorced, or there was a there was a custody case between the parents at some point in the past. Those are the things you have to notify the court about. A person filing for guardianship may have to post a bond or request that the court waive the bond. It's just kind of like insurance. It's not always, it's not required in all cases. You have to file another thing called a public assistance affidavit, which is a statement by the petitioner telling the court whether or not they know the child receives any public assistance of any, the TAFDC, the mass health, the SNAP benefits, Social Security. May have to pay a filing fee when you file for guardianship. That can also be waived depending upon your financial circumstances. So it shouldn't be an impediment if there's circumstances that it should be waived. Let's just say, for example, the parents agree to the guardianship petition. You have to file a notarized statement from the parents. It's also, I think, on a court form that the parents agree to the guardianship. That can sometimes make things easier, but it isn't always the case. If we talked a little bit about before, if the parent or the child is involved with the Veterans Administration, there has to be an affidavit about that. If the child, depending upon the circumstances, if the child is over 14, the child can also consent to the guardianship, so there's another form for that. If you are, this is kind of big and I didn't mean to throw it in at the end, but if you're, say, a grandparent filing for guardianship of a grandchild, you have to be able to prove your relationship. So chances are you're going to need your child's birth certificate and then the grandchild's birth certificate. So you see the chain that you kind of have to, that you may have to you got to prove you're related to them. You got to,
Well, what
Yeah.
about if they're adopted? Now, how do they do that chain? Or does the
Okay.
adoption already say that this is the parent?
So yes, the adoption will say, this is the parent of the child. So you'd still have to say, prove you were the parent of the child who adopted somebody, or whatever the, whatever the chain of command is, as it were. Another form that might get filed with a petition is a request for an attorney for the child, to file that request. If you are the petitioner filing for guardianship, you don't have to file a request for an attorney for the parent. You might want to file it for the child, depending upon the circumstances. So documents showing relationship. After you file the case, the court will take takes all the paperwork, and they usually on that day will issue you a notice of a hearing coming up. Might be in a couple of weeks, something like that. Issue a notice and order, and then say, here's the 57 people you need to notify, or something like that. Usually they allow you to send it by first-class mail in a guardianship case. But the court might require in-hand service if it sounds like it's going to be a tense situation. And that would be by a sheriff or a constable, most likely. If the guardianship or the guardian petitions and doesn't know where everybody is, they may be able to post a notice in newspapers. It's called notice by publication. That can be a little bit more of a bulky process involving, like consecutive notices in consecutive local newspapers, things like that. That can sometimes be an extra little bit of a hurdle or obstacle, as it were. There are also some people you don't have to provide notice to, and you don't have to provide notice to like all of the other relatives. Kind of, maybe people who might be definitely have some sort of interest in their care, but it's not like a grandparent doesn't have to notify the maternal grandmother doesn't have to notify the paternal grandfather of the guardianship. That's not required. If a parent's rights have been terminated, they're not entitled to notice. But in general, the court will say, hey, all of these people will get notice. Oh, one biggie is that if the child is involved with DCF gets notice also. Yeah. So once you've got all these documents all together, once people get notice, and then there's the court hearing, and the biggest thing I encourage people to do, some of the biggest tips is because most people are going in without lawyers. They're just going in by themselves saying, I care about this kid, prepare a little bit. Just be prepared, write down important notes that you want to tell the judge. If you have copies of documents, you bring them to court, bring multiple copies of the documents. This is just in our high-tech sort of society, you're not allowed to bring your phone in with all the text messages from the parent saying either insulting you or saying please take care of my child or whatever it is. If there's stuff like that, you have to print them all out and bring multiple copies for people. I lived in the South for a little while, and maybe you've heard of the term, you get farther with honey than vinegar. When people you might be under a stressful situation, people might be treating you like a jerk, or they might be, I think you know what I meant. Listen to people, but be firm about what you want and what you need. A court employee is more likely to help you if you say, I understand, thank you, I'll wait. Or, than leaning over the table at them and demanding this right now, kind of thing. when you go to court, listen to the judge. The judge may have latched onto something, and I've seen the attorneys do this. I'm probably guilty of it all the time. I have something I have to say. Sorry, I hit the mic there. I have something I have to say, and you have to listen to it now. Well, the judge is talking, so wait and listen to. They have a question for you, and this could be the big thing for you. Listen and ask the question. At the same time, it's okay to say, I don't know, Judge, I don't know. I really don't know the answer to that question, or I don't know where this person is, or something like that. So it's honesty and civility. Be truthful at your court hearing. When you're involved in a guardianship, expect that your first court hearing isn't going to be your last. You could have to come back in 90 days. And then after that 90 days, you might have to come back in another 90 days. And then even after that, you might have to come back in another 90 days. It just kind of depends on the situation. When you are appointed guardian, you should get from the court what's called a letter of appointment. That's the guardianship. That's what we think of more as like the guardianship decree. That will set out what your responsibilities are, what you have to do, what you can't do sometimes, set out some limitations. One of them I mentioned was maybe you can't move out of state. The judge may say, the court may say, it's pretty important you stay for this child, for the parent involved, for everybody, that you can't move out of state. And guardians are expected to act in the best interests of the child, exercise due care, diligence, and prudence on behalf of the child. So that's what I had about guardianships. I don't know if we were going to be, I don't know, how long did we have? We have an hour. Okay. What time is it?
It's 11:35.
11:35. Oh, okay. And that was 10:30 to 11:30. Is there anybody have any questions?
I think I've asked them all.
Okay. You got a chance to. That's great. Anybody else? No? Okay. Okay.
Thank you so much.
Yeah, no
Thank you.
problem.